A federal rule that limits agencies' power to regulate water pollution would severely restrict protection of water and wetlands across country, but could also be subject to objections from conservative groups who argue new rule exercises more federal jurisdiction than U.S. Supreme Court intended in a May decision. The rule, released Tuesday to redefine which United States waters, or WOTUS, are covered under Clean Water Act, U.S. Environmental Protection Agency and Army Corps of Engineers, aimed to bring federal definition into line with Supreme Court's decision, years narrowing the scope of federal mandate. In a 5-4 decision, court ruled federal government can only regulate waters that have permanent surface contact with types of navigable waters Clean Water Act arguably covers. The revised rule, which will go into effect when Federal Register coming days, removes significant tie standard that court overruled in Sackett v. EPA case May. It also removes federal jurisdiction over cross-state wetlands and revises the definition of contiguous to mean having a permanent surface connection, consistent with Judge Samuel Alito's majority opinion. Ashley Peck, attorney for water applications at Holland and Hart LLP, said new definition was broader than expected because Sackett case only concerned wetlands, but agencies removed crucial connectivity test for all waters. She added that EPA has likely decided that it will reduce future court battles by enforcing the decision beyond wetlands. The EPA reads tea leaves to some extent based on the broader stance of the court. He said, "I think that's probably a good middle ground. You'll never be able to please everybody. But I think this is the EPA's effort to prevent further lawsuits." Split reaction environmental groups and Democrats in Congress described updated rule as faithful enforcement court order, although they say the policy will remove protections from millions of acres land across country. But leading Republicans' conservative legal groups in Congress said Tuesday and Wednesday that update resulted from a rushed process overlooked the key criteria court had outlined. Tannis Fox, a senior attorney at Western Environmental Law Center Legal Group, said in an interview Wednesday that new definition could affect millions of stream miles and undermine main purpose of Clean Water Act. With Sackett decision, that purpose was undermined because the federal government can no longer protect biological and physical integrity of these waters. He said. Washington Democrat Rick Larsen, top minority member of House Transportation and Infrastructure Committee, said Tuesday he appreciated institutions' work but disagreed with court's decision. Ultimately, Congress needs step in and correct appalling misreading of the Clean Water Act by Supreme Court. Ensure that communities continue have access clean and safe water, he said. Meanwhile, conservative legal activists and prominent Republicans on